If you're a Queensland environmental consultant, this one's worth 2 minutes of your time. We're breaking down the key takeaways on whether your professional indemnity policy actually covers rectification costs for a Queensland Environmental Enforcement Order, an EEO. Alright, let's get into it. First takeaway. A show cause notice for an environmental enforcement order may trigger mandatory circumstance notification under your professional indemnity policy. In other words, that letter isn't just something to file away, it can start the clock on your insurance obligations straight away. Second, here's the part that catches a lot of firms out. Most standard PI policies are likely to cover legal defense costs, but they often exclude the physical costs of rectifying environmental harm or remediating land. So your insurer might fund the lawyers while the actual cleanup bill sits with you. Third takeaway. The statutory duty to prevent environmental harm under the Environmental Protection Act 1994, Queensland, the EP Act here, remains a personal obligation for consultants that generally cannot be removed by contractual disclaimers. Put simply, you can't just contract your way out of it. And fourth, there is some good news on the defense side. Following widely accepted industry standards, like the National Environment Protection Assessment of Site Contamination measure, known as the NEPM, may provide a statutory defence under Section 22 of the Civil Liability Act 2003, Queensland, the CLA, if your assessment is challenged. So there you have it. 4 key takeaways on the gap between what your policy defends and what compliance actually costs. At Merlo Law, we offer a fixed scope review of your PI policy wording and engagement letter, so you have a clear picture of your exposure before a notice ever arrives. If you'd like that review, get in touch with the team at Merlo Law. Thanks for watching.